Welcome to the I Now Pronounce You Divorced podcast, where we have three award-winning family law attorneys dive into intriguing topics like divorce, military divorce, custody and visitation, trust and estate planning, and all things family law. Join us as we provide a comprehensive viewpoint through the eyes of our experts and guests, aiming to educate and soothe our listeners. Get ready to tune in because I Now Pronounce You Divorced starts right now.
Hi, I'm Charles Hatley with Melone Hatley PC. Thank you for joining us for our podcast, I Now Pronounce You Divorced. I'm here with Rebecca and Dan Cuneo, and today we want to talk about something that I believe is one of the more important aspects of divorce, litigation, or any sort of legal representation, and that is preparing your clients for what to expect. The reality is, in almost all areas of law, especially divorce, clients don't come to us because they want to. They come to us because they have to. And they have questions. And we generally, as practitioners, have seen a lot of what our clients are going to go through. So, in my personal opinion, we owe it to our clients to give them a heads up. Look, this is what you're going to face. This is what you can expect. This is what my experience tells me. But in preparing your clients, there can be a point where you said too much. So, Rebecca, how do you address preparing your clients? What sort of things do you talk about? And how do you not prepare so much that you terrify them away from the process?
Right. So with a lot of clients, I like to start just very high level, right? If we get down into the weeds too quickly, it's going to get really overwhelming. And if we start talking about breaking down percentages of certain accounts and the timing of transfers and things like that, you're going to lose them and they're going to just glass over and be done with the whole conversation. So if we start out and we sort of keep it broad and we talk about, well, categorically, these are the things that we're going to have to deal with, and then we can kind of tackle them one by one, right? So we're going to need to deal with custody, and we're going to need to deal with visitation, and we're going to need to deal with retirement accounts. But for today, we're going to focus on talking about custody, what your goals are with custody, what the options are, what may or may not work for your situation. And then following up with putting it in writing. So everybody has sat in some sort of meeting with a professional, right? Maybe like a tax advisor or something like that, where you get all this information. And then later on, your spouse or your family is asking you about it. And you're like, well, I think they said to do this or that or something, but I'm not really sure because they're kind of in charge and I don't really know anymore, right?
Mhm.
So we never want our clients to feel that way. We don't want their follow-up conversation to be, I don't really know. I'm kind of just doing what the attorney said to do. So having that communication one-to-one with the client and then having the follow-up in writing. This is what we talked about. This is how we're going to approach it. And then just taking them one little bite, one little step at a time.
Okay. And you covered something about putting it in writing and making sure that the person, the recipient of the information, gets the information in a couple different ways. Verbally, in writing. Trying to make sure that they understand it. Dan, what do you find is kind of the best cadence for providing this information to a new client?
I think a conversation first and then followed up by writing. Because if you send something in writing first, then the client's going to be thinking, and it could just create anxiety and stress that you don't need to, and it's just going to start creating even more questions. So it's always better have the conversation and then follow up in writing, and then another follow up conversation. Is there any questions you have? Do you understand what we talked about? And having in writing is many benefits, as Rebecca said, but also just from if you're a lawyer from an ethics standpoint too, and a malpractice standpoint, you want to make sure that you're documenting everything. One, you want the client to make sure that they understand what's going on, but two, you want to make sure that it is documented. So if communication does break down with the client or something happens throughout the case and you have to withdraw, the client wants you to withdraw, you have kind of that trail, that paper trail of here's what's been discussed, here's what's been recommended, and here's what the client either decided to do or not to do. But then also having in writing creates the trail of, hey, I need this from you, or what's going on. Because in litigation, there's deadlines. And most of the time it's hard to get out of a deadline that you've blown. You can sometimes, depend upon the jurisdiction, ask for a motion for leave to file for an extension or a motion for leave to file an answer at a time. But those are far and few. And so you need to make sure that you're staying within the time frame of what needs to be produced either to the other side or to the court. And so having that communication with the client sets the tone and the expectation that I need these documents. Now, the other side to that is you don't want to be saying, I need it by tomorrow,
Mhm.
right? It's okay, we've talked about this. Where are you at in gathering these documents? It truly, I look at the communication as more of being that partner. And people say that, oh, we're your partner, you can count on, or we're the partner for you, and it just it means nothing to them. I would question them. Well, what does that mean to you? And you probably get that gloss-eyed look of, I don't know. But what it means for us is we're that partner as far as we're going to be with you along the way, and we're going to be not only champion and zealously advocating for you, but we're going to guide you and make sure you understand the next step. So many clients in my past experience that I've either represented from other firms or been involved in issues and attorneys I manage, communication isn't just picking up the phone and answering or returning phone calls. It's what the heck is going on in my case? I have no idea what this means. You send me all these legalese. To me, it's jargon. It's whatever language you want to think it is, but it's not the language that I speak and understand. So explain it to me, talk to me as if I need understanding, and speak to me in a way that I can understand. And it's just following up that client to make sure, all right, here's what we need to do, and this is why we need to do it. Here's risk, here's reward, or if it's documents you need, make sure you give them enough notice, but then follow up. And it's not a follow up to make sure that they're doing their job and securing documents. It's where are you at? Are you having any issues? What are you seeing? And making sure you keep that dialogue going throughout the case. And then you're really setting that expectation and that tone as far as, all right, we have this open dialogue. Now let's start looking at what's next, depending upon where you're at in your case. But I agree with Rebecca. I think breaking it down one goal at a time is so essential, because if you just do everything all at once, the client's going to get lost. And in my opinion, you're not really you're doing the client a disservice by just trying to do everything all at once. And you need to just break it down, because then the client can understand, and it can put a little bit more thought into it, and know, okay, this is my true goal and here's what I want to do. And sometimes clients come in with the goal, but it'll change after discussion with the attorney, because they don't know the law, or they may have unrealistic expectations at this time. But we can get you to where you need to be, but here's what we need to do along the way. And it's just being smart about it.
Mhm. So, Dan, when you're communicating with your clients, you talked about, deadlines. How do you, as the practitioner, decide how much time to give your clients till the deadline? Like, right, it doesn't make sense to say, look, we've got a deadline coming up in 9 months, and then 9 months from now, be like, did you hit that deadline? How do you decide, in versus tomorrow? I mean, how do you decide how much time to give them?
Right. And it I'll answer it in two ways. One, it depends on when the client retains your services, because sometimes
Mhm.
you're up against the timing as far as when things need to be produced, and sometimes you have to rush. That's never my preference. And so as a practitioner, you have to do your due diligence to make sure that you have the time to take the case and that you can take the case.
Mhm.
If there's a trial tomorrow, it doesn't make any sense to take the case, because there's nothing you can really do.
Mhm.
But at the same time, as far as when in a usual case, you have deadlines that are 9 months out or a year out, 6 months, whatever the case may be. It's letting the client know what those deadlines are, making sure that it's calendared on your calendar as the attorney. If you have an assistant and paralegals, on their calendars. And then you follow the client in status letters, whether it's on a biweekly, a monthly basis, just kind of checking in to see, here's where we're at in your case. This deadline's coming up. You may want to start preparing to get these documents. Is there anything we can do to help you out? That way it's on their radar. And as you get closer, then you really want to start having those communications. Where are we with this? What can we do? Because even though it's due within an X amount of time, we want to have the ability to review and analyze it ourselves to see where are some concerns that we have. How is your case can be affected by what you're producing to me, because we have to produce it to the other side. But we also want to make sure that if it are documents that are being requested, we want to make sure we have enough time to object to those too, because again, it's going back to timing. If we blow that deadline, you waive that objection, and then that evidence, those documents are going to be put into evidence, and it could be detrimental to your case.
Mhm. Absolutely. And one of my favorite things when approaching a deadline is to give the client the deadline, but also set a meeting with the client 3 or 4 days before the deadline of when I need what I need from the client to say, hey, is there anything I can do to help? Do you have any questions? Is there anything that I can help clear up? Rebecca, when you're communicating with clients, how do you decide what communication should come from you and what communication is more rightfully to come from an assistant or a paralegal?
Sure. So if something's purely, we need bank statements and it's the paralegal following up to say, "Hey, we
Mhm.
still need your bank statements," or something like that, that can certainly be delegated. If it's informational, it's understood exactly what it is, but anything that involves more of an explanation, more of an analysis, that always needs to come from the attorney. Even if it's just, how did the last weekend's visitation go? Was everybody on time? Were the kids happy when they came home? Did everything go okay? Even that type of thing, because there's some element of analysis that's going to have to happen. That's going to be more appropriate to come from the attorney.
Mhm.
Mhm.
Yeah, I agree. One of the things that I always want to see is that the attorney is reaching out and putting the effort in to say, look, this is what I need, but more importantly, this is why I need it. This is why I need things a week earlier, like Dan said, so that I can object, so that I can look at it, so that I can process it. Um, Dan, how much do you get into explaining the why? Like, and I'll clarify this a little bit. I know a lot of people try to use the colloquial term, you know, don't get into how the sausage is made. So, how much do you get into how the sausage is made with the clients?
Yeah, I may take a different approach, but I believe in being fully transparent and letting the client know how the sausage is made so they have a much better understanding of what's going on. The why is so important because clients they usually don't know, right? They're saying, "Okay, well here's my bank statements." And then like, "Well, why the heck do you need these?" It says all my personal information in it. And it's, well, I mean, several reasons. It's our what monies are going out because we may have to trace those, or what's coming in, and what is the balance when you separated versus the balance when you were married. I mean, there's so many implications. So giving the why as to how it affects your case, it's imperative. And to me, it's malpractice if you don't explain the why to the client.
I agree. And, one of the examples I always like to give is, when I was younger, I had a back surgery. And I remember walking into the nurses and all the medical procedures and walking out and having people that cared about me say, well, what's going to happen? I'm like, I don't know. Because I didn't know, because nobody ever bothered to explain it to me. Because the doctor talked to me for 3 minutes, the nurse would come and talk to me for 5 minutes. They would ask me to repeat all my personal information, and then they would walk out. So, in doing that, Rebecca, how do you balance, giving enough information so the clients know why what is going on versus going and talking too much, like I'm subject to do?
Yeah, sure. So I one of the things that came to mind when we were going over the topic for today was like, how do you prepare the client but not terrify the client? Right? Like some of this, there's a little bit of tough love, there's a little bit of an element of needing to have that soft touch of just, this is not unusual, this is routine, this is kind of what everybody has to go through and it'll be okay, but it is also really important. And you do need to be really specific. So there's a balancing act that needs to go on there. And I think that's going to be different just client by client, because there's some clients that come in and their anxieties all the way up here, and we need to kind of tone them down a little bit and let them know, like, we have this, right, but these are the things that we need to do, and these are the steps, and I just need you to focus your energy on accomplishing those tasks. And there's other clients that are just like too laid back, and they're like, whatever happens happens. No, this is kind of important. And it's gonna have a really long impact on your life. So that is going to vary kind of client by client. I think, again, just taking it from the high level approach and saying just kind of categorically, this is the reason that we need the information. So there are retirement accounts out there that we're going to need to deal with. In order for us to properly deal with this whole pillar of items, we have to see the bank statements, we have to see the contributions, we have to see the pay stubs, we have to see the tax returns, there's just a whole lot of backup documentation that goes into getting the right number and figuring out your entitlement. And so we don't need to necessarily dive into all of the like what if this or what if that, but we do need to just cover our bases and make sure that we have everything. And so one thing that I love that we do is right when somebody signs up with us, their very first communication with us, we're telling them we're going to need certain documents from you. We're going to need bank statements. We're going to need tax returns. The sooner you can start putting these things together, the easier it's going to be later on down the line. And it's not going to be so overwhelming in a month or 2 months because you've already done a lot of the legwork now, and we can kind of spread it out and make it a little bit easier to just accomplish one little piece at a time.
And I think you bring up a great point about proactive versus reactive communication, right? And I think that, of course, in every relationship, there's going to be reactive communication, which is, hey, I've got this question. Okay, let me answer that question. Let me react and answer that question. But Dan, how do you work on being proactive with your clients to try to answer all the questions they would have without bogging them down?
Sure. It's really the experience of the attorney. And
Mhm.
what I mean by that is anticipating what your client may ask or anticipating what those anxieties are based upon your experience in that particular issue that the client's dealing with. Meaning, are they coming in for a divorce? Are they coming in for a modification, a contempt, whatever the issue may be? Knowing based upon your experience as a practitioner, here's what at least kind of a checklist, right, of what I'm going to be requesting from you or questions that I'm anticipating. And it allows the client to feel hopefully a little bit more at ease, but it definitely instills more confidence in the attorney. And that's a two-way street, meaning the attorney feels more confident as they continue to practice and deal with issues, but then the client feels more comfortable with that attorney representing them. Because a lot of times clients will go in and they'll meet with someone and that might not be their attorney or might not be an attorney at all, and it's just trying to figure out what's going on. And then they get passed on in the client's mind and like, well, wait a second, I have this relationship or rapport with this person, I want this person, now I got to tell my whole story again. And it's having that open communication and setting those expectations so the client doesn't feel, all right, now I'm being passed on and passed on and passed on and I'm just a number to them. And it's we want to make sure that we're assigning you the attorney that we feel is best suited for you. And then it's that attorney can anticipate, all right, I know this is X type of case. Here's what I think the questions will be, and start having that dialogue so the client doesn't have to always ask the questions. Because you want the client to ask questions, of course, but you want to make sure that you're giving the client the information so they can digest it first and then potentially ask questions.
Yeah, like you said, the communication doesn't have to be just legal, right? It can be, this is how our internal processes work, so you know what to expect each step of the way through our organization, right? You call us, and this is what the next step is, and this is what the next step is. We're keeping you informed about how things work. How do you deal with somebody, Rebecca, that doesn't want to know, who doesn't want to communicate, who tells you, look, I don't want your emails, I don't want your status letters because I don't want to pay for them?
Yeah, so we've had that happen a couple of times, and usually it's not going to be a client that we can really work with, unfortunately. And because we've seen it just come back to bite us every time. So we've had clients that have said, I don't want you to reach out to me. I don't want to get anything. I don't want letters. I don't want emails. I don't want anything unless I ask you a question. Like I'll reach out to you when I have a question, and then that's when I want to have a response. The most recent example of a client who did that to us, and we said, okay, great, we'll do our best to work with you. 2 months later, she fired us. She hired another attorney. She filed a bar complaint. She, you know what I mean, demanded a refund. Like it was just a whole situation that it didn't need to be. And so I think if we have a client that comes in and says, I want to operate completely differently than everything that you all do as an organization, we have to just be upfront and say, look, this is not a relationship that's going to work out with us long term. We're very upfront in our whole intake process about this is how we operate. We're proactive. We're actively reaching out to you. We have a full-time client concierge who's also going to touch base with you and make sure everything's going okay. And so then to be upset at receiving those communications, that's not a good sign in the relationship. It's going to be really hard for us to truly partner with a client who's acting in that way and refusing to cooperate with the way that we do business.
I do think that that's tough. I think a lot of what people don't understand, and I've done it myself, is I've got to allow the professional that I'm hiring to do their job.
Hi, this is Dan Cuneo with I Now Pronounce You Divorced. Thank you for taking time to listen to this week's podcast. Please join us next week for part 2.
Thank you for tuning into our podcast. If you found this episode helpful and you want more informational content, please be sure to subscribe and join us on all major social media platforms, including YouTube. Stay connected for more exciting updates and tips.